When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.
Every citizen has a right and every citizen has an obligation.
That a plea of ultra-virus acquit or convict is very different from the plea of pardon.
Trespass is that act that interferes with the peaceful.
No matter how minute this,
right? No matter how minute.
He who comes to equity must come with clean hands. Hello out there, you are welcome to another fresh episode of the program Justify Nigeria on ACNN television, reaching from Abuja. On today's episode, our subject of discussion will be on the legal concept of alternative dispute resolution. My name is Anozichi Nomso, your anchor. Alternative dispute resolution, popularly called ADR, is designed to settle disputes outside of the courtroom with the help of impartial third party. This means that any procedure agreed to by the parties to a dispute, which they use the services of a neutral party to assist them in reaching agreement and avoiding litigation, could also be referred to as alternative dispute resolution. ADR has gained widespread acceptance among both the general public and the legal profession in recent years. In fact, some courts now require some parties to resort to ADR of some type, usually mediation, before permitting the parties' case to be tried. Joining us now in the studio to explain more about alternative dispute resolution, its legal concepts, and all we need to know on ADR is Barrister Rinze Jude Obi Obiora. He is an associate at the law firm of Dr. Onye Chibazu SAN & Co. and also a member of the Unity Bar here in Nigeria. You are welcome to the program.
Thank you. It's an honor to be here.
Thank you so much. We talk about alternative dispute resolution. You agree with me that we have millions of our viewers and audience out there that are not lawyers like you, learned profession. That's what people say. Now, please, the general understanding of the people out there and based on legal perspective, can you tell us what alternative dispute resolution is all about?
Well, as the first word in that phrase specifies, alternative dispute resolution, ADR for short, is simply an alternative, another way, a different method for parties who have a dispute, a disagreement, a quarrel. Let's bring it down simply to quarrel, a quarrel between them, to settle without going to the unnecessary stress of litigation or going to court.
That's simply what it means. So maybe I now, Nonso, Barrister, we're having quarrel. Instead of going to court street, we might decide to resort to because you just use the word simply quarrel. So anything that could be done before going to court is now alternative dispute resolution. Just simply put. Okay, but is there any situation by which alternative dispute resolution can come after going to court?
Well,
do you understand what the scenario I painted now? Is there any possibility of that?
Well, it is not really possible.
It's not really possible.
A court judgment is a decision by the court of law, which has the power to determine rights of parties. So when your rights have been determined by court, you can't explore that method anymore.
So normally it comes first before maybe when they cannot settle, they can now go to court. Thank you very much. Now, are there types of ADR?
Yes.
May you tell us?
There are different types of ADR, okay? But before I go into the types, you should understand that as an umbrella, there are two. There are non-binding methods and there's a binding method.
Okay.
All right.
Please, you explain them. Just go ahead.
Yes. Now, for the non-binding methods, there are negotiation, mediation, and conciliation.
What do you mean by that one non-binding? Does it mean it's not the decision? They are not binding with the parties, or because you have to say do it in such a way that non-lawyers like all people will understand. Go ahead.
Non-binding means that it is not really enforceable in the event that when an agreement has been come to by both parties and one person negates, it cannot be enforced anymore.
Okay.
So for non-binding, we have negotiation, mediation, and conciliation. But the binding one is arbitration.
Okay, it then means that there are types, so to say now.
Yes.
But among those four, you just mentioned four.
Yes.
One is arbitration.
Yes,
Maybe
which
that
is
one
binding.
might be the papa of all of them. Okay, can you now but explain the non-binding first? You know, you mentioned
All right.
before you now go to arbitration why is binding.
All right. Good. For the first one I mentioned, under non-binding, negotiation, in the layman's terms, is simply when, in the heat of quarrel, it doesn't involve a third party. Two people who are on either side of a disagreement decide to settle their issue, their dispute between themselves without involving a third party. And they come to terms and decide. For example, let me give you an example. There's heavy rain falling due to low visibility. You hit someone's car. In fact, there's a collision, the two of you. No one is at fault. But we know Nigerians will shout, "Do you know who I am? You hear from my lawyer. You do this, you do that." Meanwhile, this is something that can be settled through negotiation, even on the spot. How? You decide, well, I spoilt your side lamp. You spoilt my side mirror. I will pay for yours. You pay for mine. You have settled.
So that thing they are doing at that moment is ADR.
Negotiation.
Yeah, but it's ADR.
Yes. It's that simple. You don't involve a lawyer. You don't even involve a third party. Come and see who you are looking for traffic warden. But two of you have decided, I will settle this for you, settle this for me. And you see that the relationship there is maintained. Not even maintained, created.
Yes, but it's possible you might not know the person.
You might not know the person. But because you've seen this is a reasonable man, this is a civilized man, I must deal with this person tomorrow. I must deal with this person, not in the negative sense.
Yeah, no, of course. Establish relationship with the person.
Establish a relationship.
Yes, sir.
That is negotiation.
Okay.
Well, for mediation, now, not to overbranch it all, but negotiation out of the four is the only one that doesn't involve a third party.
Okay. Out of the four, negotiation doesn't, because it's just like the word, two people that are involved.
People.
They don't even need to involve anybody.
No.
But other three, including the one you're going to explain,
yes,
all of them must have a third party.
Yes.
Go ahead, sir. Okay.
So mediation, although mediation and conciliation are very, very similar, in fact, it's very difficult to differentiate between them. But let's just understand that mediation, to a layman, is simply when two parties, with the help of a third party, settle a dispute, a disagreement. The third party's role there is to help them focus on the issues, identify the issues, and then allow the two parties voluntarily,
on their own,
settle that dispute.
So A and B, they're having a disagreement on an issue. C comes in now as the mediator to isolate issues that in the better understanding of A and B, and allow the A and B to now settle their issues. That's what it is.
Yes. Okay. He is impartial. He doesn't put in his opinion. He just keeps them on track, keeps them focused. And then he allows them, he watches them, and they come to an agreement. And to even take it a step further, they can now put it into writing.
Whatever decision that comes from the mediation.
Yes. They can now put it into writing. And it can be entered as terms of settlement and entered as consent judgment in court.
And it will be admissible in the court.
You've entered as you've come to terms of settlement with your other party. It's that simple.
It's that simple.
Yes.
Okay. Then that's mediation. There's another one we talked about.
Good. Now, conciliation.
Conciliation, because you are saying there is a thing.
They are very, very similar. But the difference here in conciliation, still on those same principles of two parties in a dispute, settling their dispute with a third party.
Okay, third party will also be involved, just like you explained earlier. It's only negotiation that doesn't involve. Okay, so what's that thing different between mediation and conciliation?
In conciliation, the third party can impute his opinion.
Unlike the mediation.
Unlike the mediator who just sits.
Just guide them on track.
Just guide them. Isolates the issues. Of course, the conciliator also isolates the issues, but he can now throw in his opinion.
Counsel, this is becoming interesting. We are going to go on a short break now. When we come back, you elucidate more points on that so that our viewers will understand. Right. Please, viewers, do join us again. Hi, you're welcome to The Speaker on ACNN Television, reaching you from Abuja. The Speaker is a platform where we discuss some topical issues happening in the polity. On today's segment, we are looking at healthy Nigeria or an unhealthy Nigeria. My name is Anozi Chinomso. There is a popular statement that says that health is wealth. This means that the word healthy is the natural ability of being physically and mentally sound. When someone is healthy, there is a strong indication that the person is in a state of good health in body and mind, which is free from infirmity. In another development, when someone is unhealthy, it simply means that the person is sick and incapacitated. An unhealthy, sick, an incapacitated person does not have the ability of doing anything meaningful and profitable for himself. With the kind of wicked and unhealthy things happening in Nigeria, I am moved to ask on whether we are living in a healthy Nigeria or an unhealthy Nigeria. In a situation where doctors in Nigeria are still on strike because of lack of care and adequate welfare from the government is a perfect example of an unhealthy Nigeria. Where the federal government is using court order to threaten striking doctors why their demands have not been met is another indication to note that we are living in an unhealthy Nigeria. Someone recently asked me, why is it that these people in government are not listening to the yearnings of the striking doctors and indeed the entire Nigeria? And I told him that the reason is very simple. None of all these politicians treat themselves in any hospital in Nigeria. And that is why they're careless. Nothing seems to work in Nigeria. Everything is in decay. Decay in healthcare, decay in infrastructure, decay in education, decay in institutions, decay in economy, decay in governance, decay in insecurity architecture, decay in administration, decay at the left, decay at the right, decay at the front, decay at the back, decay up, and decay down. This is a clear state of declaration. What a country. I watch with dismay where the executive governor of Zamfara State, Bello Matawale, sharing cash gifts to Nigerian soldiers publicly. And the soldiers were hailing the governor by shouting, and I quote, we are here, and nothing will happen, unquote. What a shame. What will the international communities think of us? What will the world think of Nigeria? Allow me to be a little bit melodramatic. You imagine the 48th and incumbent governor of Texas, Mr. Greg Abbott, publicly sharing money to U.S. Marines in their camp at Gaza, Pakistan, or Afghanistan, and the Marines will be shouting, we are here, and nothing will happen. This is most laughable. We are not condemning the benevolent acts of Governor Matawale towards our gallant soldiers. But what we are saying is that there are better ways of doing things of this nature instead of this public show of disgrace. How can it be that political leaders are so greedy and wicked that they think of themselves alone? How can it be that these political thieves and demons in government have succeeded in making Nigerians to see killing of innocent Nigerians as a normal way of life? How can it be that the current administration has succeeded in making Nigerians to believe that the excessive dominion God Almighty gave humans to preside over all creatures now rests on the shoulder of cows? How can it be that the superiority and welfare of cows precedes over the affairs of men in this country? How can it be that in Nigeria today, animals are human beings and human beings are now animals? This is a clear picture of an unhealthy Nigeria. Nigeria is very sick, and that is why we do not have steady power supply. All we experience in this country is an epileptic power supply. It is only in unhealthy Nigeria like ours that a leader of a country chases rats while his house is on fire. I thought then Mr. President would have rather sent a representative to United Nations General Assembly and stay back to fix Nigeria. At least through that, the United Nations will notice his absence and further ask and proffer solutions on how to help Nigeria. I pray that this safe trip of Mr. President and his entourage to United Nations General Assembly will not be the usual annual jamborees and photo sessions, but have a mind of becoming true participants in the agenda of determining what the world is all about. We are not children of a lesser God. We are not children of a lesser God. Nigerians are not children of a lesser God. In order to justify Nigeria, I therefore speak. Until our political leaders begin to understand the actual aim, meaning, and principle of governance, which is to provide the necessary and basic amenities to our citizens, sit down and put heads together, get capable hands that will genuinely assist in fixing this country, in order to have a healthy nation where our children yet unborn will occupy and live happily in future, we shall continue to have an unhealthy Nigeria instead of a healthy Nigeria. My name is Anozie Chinonso. I just want to speak. Glad to know that you are still there, and we are still here with Barrister Arinze Jude Obiobiora. Counsel, before we went on break, you are trying to bring out that thin line between mediation and conciliation. Please take it from there.
All right. So as I was saying, the conciliator, of course, does the job of, yes, this is the issue here, this is the issue here. But then he opines in this conversation, in this back and forth. But at the end of the day, it's still the parties who come to a voluntary agreement.
Okay.
But
So the opinion of the conciliator does not necessarily matter there.
No, it still plays a role. It's still a form of guidance. It can even help the parties understand the implications, the issues better.
Counsel, where maybe husband and wife or whoever comes to their pastor to tell them maybe counseling, can we see that as a conciliatory type of idea, where he puts his own opinion, guide them and all that, and they settle? Can it be painted? Because we are looking at the best way that our viewers will understand what we are talking about.
Well, if you look at it on the surface level, it is of some sort of conciliation.
But not necessarily the actual.
But we'll get to that shortly.
Okay,
because there is a comma as to husband and wife.
Okay.
When it comes to ADR.
ADR, okay. I think you have done justice to mediation, conciliation, and of course negotiation. Now, the papa that is on his own, arbitration, because there's something, please explain to us that what arbitration is all about.
Now, arbitration is also a method of ADR, alternative dispute resolution.
But you mentioned that it's the only binding one.
It is binding. Although it still enjoys the benefits of ADR as to in regards to, in contrast to litigation, as by shorter, it's less costlier, and the rest. However, there is an arbiter involved in this process, and at the end of the day,
Counsel, not everybody there understand what is arbiter. Somebody that is in charge, that presiding.
Yes.
Let's understand, because when you call arbiter, most of the viewers that may not understand. So, okay, there's somebody there who is also playing role of a mediator in such way, but it's called arbiter now. It's just a matter of nomenclature.
Yes.
That's right. Go ahead, sir.
So now, for this arbiter, who is deciding over the parties, disputes and all that, the arbiter is the one, in fact, it's the parties. The parties have their option to choose the panel of arbitrators or the arbiter. And he decides the rights of the parties.
The arbiter now?
Yes. In relation to the issues they brought forth. Unlike litigation, the Evidence Act applies there. But it doesn't apply in arbitration. However, the rules of evidence apply. Unlike mediation.
Come again. You made a statement that unlike litigation, Evidence Act applies.
Yes.
But in arbitration, that Evidence Act does not apply, but the rules of
evidence.
Please differentiate between. This is becoming interesting. Yes, please expatiate on that.
In litigation, of course, you use laws, you use rules, statutes in general. Okay, but because ADR is not litigation, But arbitration, being binding, follows certain principles, certain rules. And the arbiter is different from the mediator because he has certain powers mediators and conciliators don't have, which is to call witnesses. So in giving evidence, you still follow the rules of evidence.
Okay. Unlike other three types of ADR.
When you're having mediation and conciliation, the mediator or the conciliator doesn't have power to call witnesses, but the arbiter can. It is seen that the two parties have given up their rights to the arbiter. And he decides. And at the end of arbitration, there is an award. Award is likened to a judgment in court.
Okay. All this is it's just somehow the same process in court, but it's just different nomenclature and all. Like this one, that this judgment, this is award.
Yes.
Go ahead.
Yes. And that award is binding and enforceable in the sense that when two parties A and B have come to an agreement and something has been decided by the arbiter and an award is given in that regard, any party who regresses gives the other party the room to enforce that award. Although, like in litigation, you cannot appeal.
Okay.
So therefore, whatever he does is fine.
It's fine. So you can't challenge it to an open court?
No, you cannot. You cannot. Oh. Although we have the understanding that in court, the judge might look at the case and be like, these two people, you have to go and do arbitration. You can't just go and do this. The court can recommend you do that. But whatever is final in arbitration is final. That award is final.
Thank you very much. You've done justice to this. Now, somehow, it's likely to what you've just answered. The decision arising from ADR, is it binding on the parties and is it final? First of all, is it binding and is it final or depending on the circumstance?
Well, remember you said ADR.
Yes.
And I already told you there's non-binding and there's binding.
Okay.
So the decisions that come about from negotiation, mediation, and conciliation are not binding. However, the decisions from arbitration are binding and enforceable.
It's final as well?
Yes, it's final. That award is final. It is not a literal award where, like we see in the Grammys, but it's still a document. But that document, we call it an award because that document contains the decisions that the arbiter has come to conclusion based on the matter before him.
Thank you very much. And now you've just done so much well in this. But oftentimes, looking at what you just explained, there's somehow less cost in ADR and all that in terms of even creating of relationship. But we discovered that oftentimes you see some people when they engage, first in pian, they go to go, just like you said, you are painting, you hear from my lawyer. What do you think that makes people not to, first of all, go to ADR before going to court? Is it that they don't have the knowledge or... you understand what the question I'm putting to?
Yes. I will treat this in a legal manner and then come to the realistic aspect of it. Legally, not all matters can be solved with ADR. Okay. For example, election matters.
No, it can never.
Matters of
no, it can never. Election petition. No.
They cannot. Interpretation of statutes
cannot.
Like the Constitution, declaration of certain rights, injunctions, they cannot be decided by ADR. And also, like I said, I would mention later,
yes,
matrimonial cases cannot be determined by ADR. For the solution of marriage, cannot be. Now, to answer the realistic aspect of that question, well, a lot of people are not aware of the importance, the casualness of ADR. ADR, the setting is even more relaxed. You can have a cup of coffee over a table.
And it's going on.
You solve your problem. You relax. You are not represented by a lawyer. But a lot of people are so used to, you will hear from my lawyer. You will hear from my lawyer. Do you know who I am? Do you know who I know? And they rush to court. And you see in some instances, you got to look at the matter and be like, this can be settled on a round table. I recommend them.
Okay, the court sumato can recommend parties.
Yes. Although in some agreements, there's a clause that provides for arbitration before anybody gets to court. But the court so moto on its own. The court on its own. During litigation can stop and be like, no, you can solve this in a more civilized manner, and it will take you less time. It will cost you less.
Thank you very much, Counsel. Now, oftentimes we hear people that said in ADR, there's this win-win concept, and in litigation is always win-lose. And let me tell you, can you explain to our viewers what that statement of ADR, win-win, litigation, win-lose?
Okay, I will come from win-win.
Okay.
And I'll bring out win-lose from that win-win.
Okay, all right.
Generally, ADR fosters friendship, maintains relationship, encourages privacy between two quarreling parties. Negotiation, mediation, conciliation, or a win-win. Like I had given you the example of the two men that hit themselves.
And
I'm settling your problem, you're settling mine.
We can even exchange numbers and we're conference.
And we're friends.
So win-win is there.
Yes. We go into a contract and we come into a problem. We hit a bypass, a problem on the way. It can be solved and we move on. However, in arbitration, it's a win-lose situation. Because that award is to the benefit of only one
person.
And cost to be awarded against the other party. So generally, yes, it's a win-win situation in ADR because both parties benefit, their relationship is maintained. Now, for litigation, it is a win-lose because, as we all know, once the court gives his judgment, you will pay so person so amount.
And good on appeal.
This person is losing, and this person is gaining. So that is the difference. Generally, in court, there's a winner and there's a loser. But arbitration is trying to calm that down. And be
like somebody would say, be calming down.
Yeah, be calming down. You can win, you can win. You can benefit from this, you can benefit from this. That is the concept.
Thank you very much. We have few minutes to end the program. Now, all these things you've explained, facts, even somebody who is not a lawyer might even want to be a lawyer because you explained it very, very detailed so that people understand. But what is your general advice and your final word to our viewers concerning all this?
Well, alternative dispute resolution is a better, less costly, as in even a more comfortable way to settle some disputes. I would advise our viewers to also explore, tell others to explore this opportunity, this method. Because, like I said, you don't need to pay a lawyer. You don't need to shout, so do you know who I am? You can just sit down on the table and you settle that problem easily. A litigation will take you years. You hear that there are backlogs in court. You hear that your lawyer this, your lawyer's professional fee alone scares away some people. But with ADR, you don't need to face such. Your matters will be resolved amicably. You even create a new relationship or you maintain that relationship.
You create a relationship or maintain that relationship because of ADR, simply telling us that ADR must be the best before we go to an open court. We want to appreciate you, sir, for coming. And I pray when next we call out of your busy schedule, you oblige us to come. Thank you very much. Thank you so much. It is not the wish of anybody to engage in any issue that will constitute disputes. But the factual truth still remains that dispute will always arise as long as this life is concerned. People always rush to court whenever they are in disputes, even when it will cost them more, such as finance, relationships, and lots more. It is therefore advised that whenever parties are in disputes, they should endeavor to first of all resort to alternative dispute resolution, ADR, in settling their differences. This is because you always have the technique and result of win-lose in litigation, while in ADR generally you end up with the concept of win-win except that of arbitration. This is where we draw the curtain on today's episode of Justify Nigeria. Join us same time, same station, on another fresh episode of the program. Until then, this is Anozichin, so urging you to remain faithful and bye for now. When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individuals. if you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation. Justice must not only be done, but it must be seen by all to have been manifestly done.